Welcome back to America Decides. Great to have you with us. A federal judge in Texas has, for the moment, blocked the Biden administration from pushing forward a program that could offer a path to citizenship for about 500,000 undocumented immigrants married to U.S. citizens. That's very key. 16 Republican attorneys general challenged this policy. It was announced in June. The Department of Homeland Security began accepting applications just last week. I want to bring in our immigration reporter, Camilo Montoya-Galvez, who joins us from Tempe, Arizona. Camilo, always great to see you and have your expertise. Describe how this plan was meant to work, and just start there, and we'll go from there.
Hi, Major. This court ruling is a significant blow to one of two major immigration actions taken by President Biden back in June earlier this year. As you know, the president cracked down on asylum processing at the border through one executive action, but weeks after, he issued another one that created this program designed, as you mentioned, to grant temporary legal status to the undocumented spouses of U.S. citizens, as well as a more streamlined process to get green card status, permanent residency, and ultimately U.S. citizenship. And as you mentioned, it would benefit hundreds of thousands of unauthorized immigrants who are married to U.S. citizens, have lived here for at least 10 years, Major, and pass background checks. It is very important to note that this program would not benefit any new arrivals. Those people who have been crossing the border illegally over the past few years in record numbers would not be eligible for this process, and people with serious criminal records would also be ineligible. But now, under this court ruling, that program has been paused. That would have allowed people not only to get those work permits, but also a green card status without having to leave the country, because right now, Major, anyone who marries a U.S. citizen is generally eligible for a green card, but people who have entered the country illegally must generally leave the country, go back to their home country, and then come back to the U.S. legally to get that green card. But they can actually trigger a 10 or 3-year ban from the U.S. in that process. So that prompts many families to forego this process and to remain in legal limbo, if you will. So President Biden actually issued a statement today saying that this policy would promote family unity and that this court ruling could force families to separate. But of course, as you know, these Republican-led states are arguing that this is a policy that rewards illegal immigration and that it exceeds the presidential authority on immigration.
And Camilo, on what basis, legally or constitutionally, did these Republican state attorneys general challenge this? And in what degree did the judge's ruling reflect their interpretation of the law, or just say it needs further study?
That is a critical question, Major. Texas and the other Republican-controlled states challenging this policy have denounced it as an amnesty for people who are here in the country legally, and it does benefit people who are in the country illegally or without legal status, undocumented immigrants, as we refer to them colloquially. But it is important to note that it only benefits people who are already on paper eligible for a green card because of that marriage to a U.S. citizen spouse. Nevertheless, the Republican-led states are arguing in federal court, Major, that the parole authority that the Biden administration has justified this policy and has based its policy under does not allow the administration to create a categorical class-based program for hundreds of thousands of people who otherwise would not be eligible to get a green card without having to leave the country. The judge, importantly, Major, has not ruled on the merits of the case on those legal arguments. Instead, he issued an administrative order to preserve the status quo before the program took effect earlier last week. And so this order is valid for 14 days, but he suggested in that order, Major, that the program could be halted through at least October, that he could extend that pause on the policy. So it is possible that this program, which is a signature immigration policy, could remain blocked through the election.
And then this judge who intervened is probably not the last legal word. At some point, it would be appealed, I would imagine, by the administration to the appellate court of jurisdiction and then possibly to the Supreme Court?
That is right. The administration can actually right now ask the New Orleans Appeals Court to stay that administrative pause on the policy. And if that does not go their way, they can also ask the Supreme Court to take action and intervene on their behalf. But the administration has not taken that action yet. We are expecting both parties, the Republican-led states and the Biden administration, to submit legal documents in the case, and then the judge to rule on whether or not to extend this 14-day pause on the program. So we will keep you all posted.
Camilo Montoya-Galvez, always keeping us posted from all parts of the country, in this case, Tempe, Arizona. Thank you very, very much.